Hello, everyone. Harry here to talk about today's big arraignment of Donald Trump and co-conspirator Walt Nauta and what comes next, especially given that Judge Eileen Cannon, at least for now, has the reins of the case. All right, arraignments are generally simple. You never know what kind of circus will come to town when Trump shows up. Here, there was basically none. His date with Federal Destiny, was 3 p.m. in Miami. Showed up about an hour early, which is, normal. Advised by his lawyers who did the real talking today. So at 3 o'clock, a magistrate judge. That's not a district court judge, not someone who would preside over a trial, and not even the magistrate judge who works regularly with Eileen Cannon. That is to say, not even the magistrate judge who will be seeing otherwise, just the duty judge. So that judge is on the bench. Trump is in the courtroom. The case is called. The magistrate judge gives the opportunity to have the indictment, all 44 pages of it, read. Trump waives that right, which is his constitutional right to have it read in open court. And they asked the plea. Trump's lawyer, not Trump, in Manhattan, Trump stepped forward and said not guilty. Here it was his lawyer, who seems to be the new lead person, Todd Blanche, who said not guilty, Your Honor. Trump previously, this is what happens after you arrive in court, but before you're actually arraigned, had fingerprints taken, but this was all delicately negotiated out. It was without ink. He didn't have to soil his fingers. They did it electronically, and they agreed not to do a mug shot. It is special treatment, but special treatment under the law for someone whose face is very well known, and Trump's is. So that's not an outrage or kind of favoritism. We don't know. Nauta had to take his fingerprints, and he probably did have to take a mug shot. And there is a shot now of Trump in the file, but it won't be released. Okay, so Nauta, recall, as the co-conspirator. He's represented by a high-powered defense attorney named Stanley Woodward, who really should be able to protect his interests. We'll talk about him separately down the line, but it doesn't seem like this is a smart move from his standpoint. But there you have it. Anyway, he pleaded not guilty as well. All right. The magistrate judge made preliminary determinations as to conditions of release. That's where bail or even detention normally would come in. Sensibly, he didn't impose bail, let Trump go on what you call your own recognizance, and same with Nauta. That may be formally revisited. There may be the United States has a right to a hearing in which it tries to argue to a magistrate. This would probably be Cannon's normal magistrate. Hey, we need bond set here, presumably in the millions, or they just might let it fly. In other words, just not worry about it. So anyway, with that, they went on their merry ways, but the magistrate ordered the parties, the Department of Justice, I think in the first instance, to put together a list of people that Trump should be known he can't reach out to, especially given his proclivities to trying to influence witness testimony. That detail almost certainly was shared with the district court judge. So they will say, don't try reaching out to Evan Corcoran and talking about the case, etc. Other witnesses too. Trump will say, hey, I work with them. I need to. The department will say, you don't need this one or that one. A big question there is Tony Nauta himself. Trump not only works with him, but he's a co-conspirator. And it seems to me they've got a right to plan their defense. So if the order was entered saying don't talk to Nauta, I think that would be reversed. on appeal if Trump chose to challenge it. And I think our assumption should be that he's going to try to challenge everything. It's his MO, and it's the best chance for delay. So there, in the normal order of things, a decision would be made on conditions of release. I think he'll just be, let release on his own recognizance. Then there would be a setting of a hearing schedule. Now, there was suggestion on TV Cannon might just issue a schedule. Seems unlikely to me. I think the next move is for her to call the parties together for a conference to help determine a schedule. If that takes a long time to happen, that'll be the first sort of queasiness in our stomachs that she's going to be in a delay game. But I think the scheduling should be in front, should be discussed by the parties. Scheduling of what? Well, Trump is, so here back, the overall arc of what happens in a criminal trial will happen here. He was arraigned. There will be a decision on whether on what conditions to release him. The United States will be ordered to propound discovery under Rule 16. They have a lot of it, and they'll turn that over to Trump, who will happily, his lawyers, pour through it and try to get, what comes next, which is a whole long period of pretrial motions, including a motion to dismiss, including for prosecutorial misconduct, which will come up soon, and all the sort of big ticket motions that the defense will want to bring. There will then be all kinds of smaller gauge motions involving specific evidence, calls, and the like. And motions for specific procedures involving the classified documents that are in the case, whether the jury can see them, etc. And Corcoran's, the use of his testimony, those would normally be closer to trial in what's called motion in limine, but they don't have to be. Trump could well bring them now. Cannon could well indulge him, especially on the classified stuff. If she makes a ruling that the United States doesn't like, they can go up on appeal, and if it's really outrageous, that would be a anchor for them to challenge Cannon's continued service on the case. But they'll bring sort of big motions that say this doesn't even state a crime, or these things happen, like prosecutorial misconduct, and therefore you have to dismiss the case, etc. And an important question is whether or not they will fold in things that you might think would otherwise be just before trial. But those are going to be the things that if she uses them for, puts them under advisement for a long time, could really delay the indictment and push it over to after November, which just strikes me as a really grave disservice to the American people, whomever they support. It's exigent that they know if they're, voting for a convict. Okay, but that's a long stage. So very basically and briefly, the sketch is arraignment happened today. Conditions of release may well happen again, depending on the United States. Production of discovery will happen shortly, and then a schedule for pre-trial motions, like a motion to dismiss, and those themselves take months, after which, as we're looking at trial, there'd be other motions that are considered more kind of in line with how are you going to, specifically run the trial. And you put those together and you're on the eve of trial, which one would hope would be next spring or summer, but one would fear would be with Judge Cannon in the chair after the election. So there you have it. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.